Hello again, YouTube. I wanted to talk briefly about county dictators or judicial terrorism. In Isabella County, Michigan, Paul Chamberlain created an administrative rule numbered 2015-2, I believe. And he's allowed to do that, of course, in the Michigan court rules created by the Michigan Supreme Court, whom I've already spoken about being complicit in child trafficking and the intentional deprivation of rights under color of law and in child protective proceedings, and again, their complicity in the obstruction of justice and denying Michigan homeowners a right to seek relief based on fraudulent foreclosures conducted by MERS, a company without standing. Essentially, the Supreme Court's ruling that you don't need standing to sue anymore. You just get an idea in your head and take it to court, I guess. You don't have to have interest in debt to sue somebody for money or take their property, I guess. But what I want to talk about right now is the environment that we're living in, the state-created environment. We've got Paul Chamberlain as the chief judge. He's been the chief judge in Isabella County for a number of years, I think over 20, I'm not sure. But he created this administrative rule, which is within his designated power and authority according to the Michigan Supreme Court in Michigan Court Rule 8.112. And you should take a look at that, because the chief judge is allowed to create administrative rule to govern the internal management of courtroom operations. Well, what Paul Chamberlain has done is he's essentially created this administrative rule that is being imposed on everybody but what would rationally be considered the internal operations or administration of the court. He's essentially converted that ability to create administrative rules for the court to creating acts of legislation that govern everybody but the court and the internal management of the court. This is extremely hazardous, allowing our judges to legislate from the bench. What a pompous ass. Wow. Not only is Paul Chamberlain attempting to govern the people through legislation that he created and plans to enforce through the provisions of contempt of court, including fine and imprisonment. It's like $7,500 if you take a cell phone into the courtroom now. His policy, number one, bans the First Amendment, essentially, from public property. That's a problem. Yeah, public property. We can't record our public servants. It's a travesty. Anyways, chief judges don't create legislation at all, period. It's also a direct violation of the separation of powers provision of the Michigan Constitution and our federal Constitution. Whew. Racking them up there, Paul. Last time I was in court, in addition to the paid mercenaries, the employed court private security firm that acts as court bailiffs in Isabella County, according to the bailiffs themselves that I spoke to. There were sheriff's department personnel. The last time I was in court, I don't know if they were expecting to have to arrest me or whatever for bringing in a cell phone or a recording device. I'm not sure, but it's ramping up here, folks. It's ramping up. Michigan Court Rule 8.112 allows a chief judge to create a policy for the internal administration of the court, and how a chief judge of 20 plus years can determine that to mean govern the people is completely beside me. I'm baffled. not only is he creating legislation to govern the people, he's also excluding bar members and the internal court staff. So if you work at the courthouse now, there's an administrative rule that says you can bring in your cell phone, but the people cannot. Paul Chamberlain's legislation is just pure evil. There's no other way to say it. There's no other way to say it. What? Anyways, Paul Chamberlain quotes as his authority a new Michigan court rule that was developed by the Michigan Supreme Court in 2009. That essentially converted courtroom decorum into everything but. Michigan Court Rule 8.115 originally had Section A and Section B, and they were the United States flag and as one of them, and the judge shall wear a robe as the other one. That was courtroom decorum. In 2009, the Michigan Supreme Court changed the title of 8.115 to include, look it up, to include some verbiage about portable electronic communication devices. Okay, that's one phrase, portable electronic communication devices. And the ways our laws are written and rewritten and overwritten and developed and designed to actually have a degrading meaning over time, it was written that way so that arbitrarily a judge like Paul Chamberlain can throw a comma in there and change the meaning entirely, and that's what's happened here. And also, Paul Chamberlain has drug his friend in, Thomas Ludington, who's a federal court judge over in Bay City, which was good in one regard because I got to look at the case itself. But the issue here is recording public officials, and you know they like to defray what they're talking about. I mean, this is part of the process. This is how they work. This is the way their minds think. When they take away or they add a comma or something into portable electronic communication devices, now all of a sudden it means something entirely different. And that's exactly what Paul Chamberlain did. He put a comma in or two in that phrase, portable electronic communication devices, and changed its meaning entirely. So currently, if you live in Isabella County, electronic devices are one of the restrictions now. So if you have a pacemaker, sorry, you can't come to court, according to Paul Chamberlain's new policy law. And, you know, there's a reason why the original phrase, portable electronic communication devices, didn't have any commas in it, so that it was clear. Its meaning was understood. Portable electronic communication devices, you know, walkie-talkies, cell phones, things that communicate. Portable electronic communication devices, not digital audio recorders. The ability to tape record has been around 80 years longer than cell phones, but all of a sudden now we have this legislation about cell phones that just seems to also include the ability to tape record. You know, obviously, if it was an issue 80 years in the past, they would have rewritten the laws back then to say, hey, don't record our criminal judges committing crimes in your public facilities. No, that's not what happened. Anyways, Paul Chamberlain claims his authority to ban basically everything. Insulin pumps, hearing aids, a big one. Yeah, if you find yourself a defendant and you can't hear what's being said, you might actually be better off. Less traumatic, for sure. But anyways, this is a terrorist act by a chief judge in Isabella County. Courtroom decorum should have never been changed in 2009, and the way it was written implies that its intended misuse was not only projected but perceived and counted upon. The way the language is written creates its own subjugation to interpretation. Even if Paul Chamberlain could create policy in accordance with 8.115 under courtroom decorum, that's a recent change by the Michigan Supreme Court in 2009, he can't govern the people with his administrative rule. I'm not employed by Paul Chamberlain. I'm not employed by the county. These rules are for them. They're not for me. They're not for the people of Michigan. And every county in Michigan that's forcing this local legislation on the people are committing acts of treason and terrorism. Now, it should be clear that, if you're a judge sitting on the bench and you plan to commit crimes, you don't want anybody to record you doing it. Why don't you just say that, Paul? Instead, Paul calls in the Morning Sun, already partnered with the county to report what the county wants. They've basically become the mouthpiece of Isabella County. Calls them and CM Life in and says, well, we're creating this new policy for the safety of our people and the integrity of the public record. Well, here's a concept for you, Paul. If I record you committing crimes and I change it, why don't you arrest me for tampering with evidence instead of refusing to allow me to collect it in the first place? Wouldn't that be easier? If, after all, you are keeping a firm public record through transcripts and what have you, wouldn't it be easy to prove that the transcripts are being manipulated? The bottom line is you don't like me publishing your crimes. And sorry, this is public information. The people need to know this. And if you don't like it, I guess you can retire, quit committing crimes, and move on. Or, confess. But you cannot create policies that subvert and pervert the Constitution of the United States and our First Amendment. Our First Amendment rights, secured by the Constitution. You cannot abridge freedom of the press. And I am credentialed in my own way. That's funny. I see people like the reporters at CM Life. They covet their credentials, which are basically state requirements as to what they can and cannot do. And then all of a sudden the state's saying, well, you cannot report on, criminal judges, or you cannot do this, or you cannot do that. Well, the state of our courts is in serious disrepair. And the people need to know it. The people need to know that the obstruction of justice is now the primary concern of our justice system. The obstruction of justice. We're not having it, Paul. Big man Paul. Boss hog Paul. You don't create my legislation. You don't govern me. Your policies have no force or effect on me. Okay? And just because I'm not willing to have myself thrown in jail by ignoring your policy doesn't mean that this isn't coming to a head. And I'm not taking this to the federal freaking court in front of a Thomas Ludington who's already made an unconstitutional ruling with regard to this, and spend the next 5 years of my life fighting your crime, civilly. That would be an indicator of an insane individual. You've broken the law. You're forcing your administrative policy on the people as though you are a legislator, and you're excluding yourself. How convenient. Doesn't that make you a dictator? We live in a republic, okay? Not a democracy, not a dictatorship. You don't get to write my laws, and I don't have to follow your administrative policy for the courtroom staff because I'm not your staff. The people of Michigan are not your staff. You can't administer the people of Michigan under administrative rules that you can create for the internal operation of the court. Anyways, I just wanted to get that out in a real quick video. I've got the Michigan court rules published on my Facebook. Check it out. I need to get these videos up a lot quicker and do a lot less editing. If you can't look up the Michigan court rules yourself, then find somebody who can. They're pretty simple. Again, the court rules being used for Chief Judicial Terrorist Paul Chamberlain to create legislation for the people of Michigan that he quotes is 8.115, and the authority given to a chief judge or trial court judge to create administrative rules is found in Michigan Court Rule 8.112. And I should also let you know that there is what are known as the annotated version of Michigan court rules and the annotated version of Michigan compiled laws, and those used to be readily accessible online, but they're not anymore because they go into much greater detail. And the reason I bring that up right now is because I would like the people watching this video, especially those that live in Michigan, to know right now that in the notes section of the Michigan court rules referenced, there's also case law, okay, that back up these rules. And in there you can see that these court rules are these court decisions reaffirm that the court rules are not intended to govern the people, but only the public servants, the court staff, the court officers, and that includes lawyers. Okay, the court rules were originally written to govern lawyers, to give the court a jurisdiction to operate in. Okay, that's what it's about. That's why lawyers are court officers. They're officers of the court. Well, for that privilege, they have to abide by the Michigan court rules. Okay, these aren't laws. These are Michigan court rules. They govern the lawyers and the court staff. And anyways, that's enough for this. Eventually I'll remake this video and I'll put in excerpts from the laws I'm quoting, including the annotated version with the prevailing case sites. Till next time.